litigation as a means to meet the goals and objectives of our clients.
In the midst of this lockdown that we're all facing as a result of the government's response to the coronavirus, many property owners, as well as tenants, are in place, not leaving very often, and in the house and in their current living situation. Now may be a time that you're thinking, should I sell? Maybe your tenants are interested in buying your unit and you've been asked from your tenant if you'd be willing to sell your unit, your real property, your co-op, your condo to them. Sounds like a terrific idea. Maybe you're going to get a great price, maybe you won't. But that's not what we're talking about today. What you have to be aware of is that you, as the owner of the property, could be facing as much as a 12% real estate commission on the transfer of that property to your current tenant. Let's take a look at the documents and see if you fall into this category of unwitting and perhaps individuals who can change the course of their future with this little bit of information and knowledge. Okay, so this is a real estate listing agreement. Many of you signed these agreements when you listed your unit or your real property for lease with a brokerage firm. This particular agreement is for Corcoran Group Real Estate. I'm not picking on them, although they happen to be the one who did give my client some grief. And what my client faced is something that you may face, whether you know it or not. So let's take a look at the agreement. The listing agreement for rental of your unit is a relatively straightforward agreement. This agreement here was 2 pages, and the client in this case signed this agreement and did so at their own peril, and we'll discuss why and how. I want you to take a look at this little paragraph here that starts with, in the event the tenant purchases the apartment, whether during the term of this agreement or afterward, Corcoran will be recognized as the procuring broker of the sale, and our fee for service to be paid by you will be 6% of the sale price. If the tenant was introduced by a cooperating broker, Corcoran shall pay the cooperating broker a fee for service under a separate agreement. This particular provision exists in many different forms in real estate broker listing agreements. You should be very concerned that your agreement may have a similar provision in it. I urge you to dig into your files and pull out your listing agreement for the rental of your unit and look for any kind of language that talks about the broker that you entered into the agreement with being entitled to a commission under certain circumstances. And in this case, and in the most common case, if in the event the tenant who they find for you and who you enter into a lease with decides to buy the unit. One thing that you should know is that the statute of limitations with respect to these particular clauses don't begin to run or are not triggered until you as the owner sell the property to the tenant of your property. 6 years will run from that point in time. And you don't want to be the person who gets a letter from their real estate broker advising them that here is an invoice for $65,000. Congratulations on the sale of your property to John Doe, who was a tenant that we found for you 8 years ago and who's been living in your apartment without our knowledge or consent or any other basis or reason to know happily, and now all of a sudden decided they were going to buy the unit from you. Those letters do go out, and you have to be aware that as part of the ordinary operations of these various real estate brokerages is to track the property sales in your neighborhood to see if you're buying or selling properties, and then they're going to see who bought it, and they're going to see if that was a tenant, and they're going to see if they were entitled to a real estate commission, and if they were, you're going to get one of these letters. Now, in the event that you decide that you have a current tenant in the unit and you're now going to list your unit for sale, you didn't bother checking your prior brokerage listing agreement, and you entered into a new real estate brokerage agreement with the lovely brokerage house down the street, Keller Williams, Compass, Triple Mint, whoever it is, and you enter into an exclusive listing agreement with them, and they're going to sell your unit. Now, what happens if the best buyer who shows up to buy your house or unit happens to be the tenant who's in the premises right now? Well, the other broker, Triple Mint or whoever it is going to say, well, thank you very much. Now you owe us a commission for the sale. And you may get a call in 6 months, 5 months, a year, 2 years, 3 years after the transaction from your friendly broker, in this case from Corcoran, who says, hey, we just noticed that your tenant purchased your house. And pursuant to our agreement that we signed back in 2010, you now owe us $65,000. Don't let that be you. You got to know this agreement that I'm showing you now and how it impacts your future transactions. But you also have to know how to protect yourself from getting into this situation in the first place. So don't forget, brokers are very special people. I like them all. Usually they approach you and they're your friends and they're working to help you, right? And as the owner of the property, you would think that you're the one with the biggest bargaining position, because here you are with a $650 or $10 million property and you're in the driver's seat. Well, you should always have your little pen handy as you read through these agreements. You should also have the number of your lawyer handy if in the event you don't understand what it is that you're signing, or if you say, listen, I'm a real estate professional by trade. I buy and sell. I know the markets. But when it comes to the intricacies of reviewing these contracts with a fine-tooth comb and being able to look around corners, I'm going to just call my lawyer and give this to him in the first place. Those are our favorite clients because we can often intercede and help them at that point in time. And your lawyer would be very happy to review this document for you. Make sure they saw this video first, though. Now, with your handy pen, you got to read through this agreement. And yeah, we look for the major terms. Is it the right property that's listed? Is this the right rental amount that we asked for? How long is the agreement effective for? And what other kinds of provisions about the commissions that'll be paid, etc. But you got to get down here to this seemingly harmless 1, 2, 3, 4 line paragraph and not just breeze through it. You have to understand what it is that you're signing, and don't be afraid to negotiate with your broker to take this provision out or limit it for a term of years, or to do whatever you deem reasonable to protect yourself. Because at the end of the day, this agreement is a legal binding agreement, and you don't want to be the guy or the gal or the company or the purchasing or sale professional in your particular group that steps into a landmine without even knowing it. And now instead of paying the broker 6% commission for your beautiful sale of your $25 million townhouse, but now you got another broker saying, well, you owe us 6% of that sale as well. 6 plus 6 is 12%, and it's not what you bargained for. It is what you bargained for, but it's not what you should have or could have bargained for. I hope that you found this advice useful. Pass it along to your friends. Pull out your old agreements that you have with your brokers. Be safe out there and be diligent.